43, People versus Derek Smith, 21105 FC.
All right, so today's date and time is set for a couple of motions that have been filed by the defendant. Looks like relief from judgment, motion to withdraw a plea, motion for a Ginther hearing, evidentiary hearing, motion to dismiss charges, and then again, a motion to withdraw a plea. I've had a chance to go over all of that, Ms. Kracher, as well as any responses, so I'm ready to proceed. You may, I guess, let's address the motion to dismiss first, and then we can address the motion to withdraw the plea. And again, I've read it all. You're welcome to highlight what you need to, and then I'll hear from the people and we'll go. Okay.
Okay. First of all, good afternoon, Your Honor. Your Honor, Court's records can first start with the motion to withdraw. Motion to dismiss charges. And I'll start with that. During this case, the defendant had raised several issues about some missing evidence, okay? Particularly a ceramic ladle. And I know that there's been some confusion over why the ladle is so important and how it violates my client's due process rights. And so I hope to clarify that. The defendant has the right to put on a full defense, a full entire defense, be able to bring to the court all the evidence, all the arguments as possible. The ladle was an important part of that because it was a piece of evidence in the sequence of the event that it was an important part of evidence in the sequence of events of this case. The ladle was easily acceptable by law enforcement. It should have been secured because the claim of complaining witnesses is that she was hit with it. How Mr. Smith is denied his due process rights is that he has no ability to examine that ladle for fingerprints, any kind of DNA evidence that would tend to believe the claim made by the complaining witness that she was hit with the ladle. Therefore, he can't fully put on a defense when he impeaches her by saying, you know, we don't have this, you know, we could use the DNA evidence to impeach her on that. I just think that also the defendant has brought that to the attention numerous times, and that the attorney of record, Mr. Bernstein, failed to investigate that issue fully. That's what I have to say about that motion at this time. I think his due process rights were violated. I think he didn't have an opportunity to present a full defense, and I would ask the court to grant the motion.
Okay. Ms. Blanche, any response on that motion?
Just briefly, Your Honor. He wasn't charged with hitting her with the ladle. We could have added an extra count of domestic violence for the hit from the ladle. We didn't do that. This is a charge involving a knife where he stabbed the victim numerous times and slashed her in the face. So that I still don't understand how the ladle is any evidentiary that has any evidentiary value. If he's using it for impeachment purposes, he could still, or the defense attorney could still impeach her on the stand and say, well, no ladle was recovered, and you said that you were hit with the ladle. You know, you could still impeach it, but to sit there and pull DNA evidence off of a random object that we didn't even charge for, I think is pretty ridiculous. I found a case that's pretty on point with evidentiary value. The duty to preserve evidence extends only to evidence that might be expected to play a significant role in the suspect's defense. 467 U.S. 488, the exculpatory value of the evidence must have been apparent. And in this case, it's not apparent how the ladle played any role in what he was charged with. He was charged with assault with intent to murder based on the fact that he stabbed her numerous times with a knife.
I may respond. Sure. Okay. So first of all, it's not ridiculous, okay, that the ladle should have been preserved. Yes, true, he's not charged with assault and battery. But it's a key piece of evidence in the chain of what happened. It's a key piece of evidence that may prove his innocence. It's a key piece of evidence to show that the complaining witness in memory is incorrect or, for impeachment purposes. And therefore, as Ms. Blanche has classified it as exculpatory or non-exculpatory, I would tend to differ with her. I believe it is exculpatory. I believe it basically proves to a bigger extent the lead into what happened afterwards, especially as the court has reviewed all the evidence, looked at the police reports and all of that, there's a lot of conflicting statements that I listed in my other motion to withdraw a plea. So I would ask the court to grant my motion. Thank you.
Okay. As the defendant dismiss, the defendant argues that a ladle has not been located nor forensically examined. The defendant claims that this ladle is favorable to him because it is either exculpatory or impeaching. Should dwell for a moment on that argument. At the preliminary examination on February 23rd, 2021, Ms. testified the defendant told her he was going to kill her, but before she could turn around, she endured a blow to the head. She testified from her peripheral vision she recalled seeing a ceramic ladle. She was then stabbed several times. The defendant was charged with assaulting Ms. Lee with a knife and not a ladle. The court is also perplexed and does not understand truly what the evidentiary value of the ladle could be. I do not see how the ladle is favorable evidence. It is not exculpatory, and if it were used to impeach a witness, that is still a possibility, as the people have indicated. It is certainly possible that the complaining witness in this case did not get a good look at what struck her from behind. She testified that it might have been a ceramic ladle, but I guess the question that I am left with is, therefore what? If the ladle had been, again, the alleged weapon used in the ensuing, assault, then that is a possible piece of evidence that might have evidentiary value. But as Ms. Blanche points out, people charged him, and again, the assaulted weapon was the knife and not this alleged ladle. And so therefore, based on my review of everything, I appreciate the case citation. I mean, we did look at the briefs, and there's not enough potential exculpatory value in this piece of evidence for the court to grant this motion. And as far as the defense ability, it could have been used to impeach the defendant. To impeach the witness. But I'm not sure that even might have been helpful. I mean, we didn't have a trial in this matter, and that's the next motion that's up. But basically, at this time, I am denying the motion to dismiss based on that. So that motion is denied. Let's move on to the motion to withdraw a plea.
Thank you, Your Honor.
Okay.
Your Honor, is there any possible way that I can address the record, please, or just?
Absolutely not. You've had a million lawyers, and I've let you address the court before, and we are proceeding with your lawyer to address. Your opportunity to address the court is foreclosed at this time.
I'm
Until
just reserve the issue for appeal, Your Honor. That's it. I can tell you the value of the ladle if you sit here and let me explain.
Mr. Smith, you have told me the value of the ladle on more than one occasion. This is your last opportunity. Your lawyer has done an absolutely fine job of presenting your case. So we're going to move on to the motion to withdraw a plea.
Well, okay, no problem.
Thank you.
If you won't let me defend myself, then that's just what it is, because you're violating my.
Mr. Smith, I need you to be quiet.
I mean, what do you want me to do?
Mr. Smith, I need you to be quiet.
Like I said, Your Honor, I'm going to put this on the record, unless they put a muzzle on my mouth, because this is wrong. She's saying that she was hit by the ladle, Your Honor, to minimize her role in this incident.
In here.
She's minimizing her role. She never got hit by a ladle. Fingerprint the ladle. Where's the ladle have to be fingerprinted? She never got hit by this. She's saying this only to cause a distraction on her having to attack me.
Okay, Mr. Smith, I'm going to mute you at this time. Your lawyer is going to argue this motion, and then we're going to proceed.
So I would like to break this down into a couple of arguments that hopefully will be more organized and that the court can hear. First of all, the relationship between Mr. Bernstein and Mr. Smith. Mr. Bernstein was his previous attorney. Broke down near the end, and to say it was a relationship working together would be a little bit of a stretch near the end. As the court has read, the first paragraph sort of lays out, the chronological events. But back to Mr. Bernstein, the defendant asserts that Mr. Bernstein had not been pursuing his case with vigor for a couple of reasons. One, the ladle. The other is pursuing the knives to have any kind of analysis done on DNA. That, in addition, in addition, the defendant told Mr. Bernstein on numerous occasions that he was innocent of that crime. And that because Mr. Bernstein's conversation was overbearing, provided a sense of hopelessness, and basically browbeat Mr. Smith to accept this plea agreement, I believe Mr. Bernstein did not serve his client well. I want to point to the court's attention that on several occasions during the plea, that Mr. Smith, one, has always inserted his innocence. Secondly, he always inserted that Mr. Bernstein had not been fully investigating his case, and that Mr. Bernstein had explained to him that this is a hopeless case and that he should, not go to trial. Also, I want to talk about how, again, that made Mr. Smith feel. Made him feel boxed in, made him feel he had no choice but to accept the plea because he didn't have an attorney that he felt was working in his best interest. In order to withdraw his plea, Mr. Smith has to assert his innocence. And there's several factors here that I think the court has read. The court seems to be very familiar with the case. And I've attached exhibits. The first is that the complaining witness from the 911 calls, police reports, the hospital report. I want to make a correction on paragraph 17A. It should be complaining witness, not the defendant. The complaining witness from the 911 call, the police reports, the hospital reports, the witness stand, and preliminary examination has been inconsistent. She hasn't told the same story twice. She hasn't been consistent. She can't get the facts. An example of that is that she reported a loss of consciousness in the police report, but in the medical report that I attached, she reported no loss of consciousness. Mr. Smith also had some defensive, what I would classify as defensive injuries in nature, and it shows that he was defending himself. Further, there was 2 knives found. I think that this is important. That leads to his innocence. There was 2 knives found, and therefore this fact is a conclusion that the defense of self-defense is a viable one. Further, permission to withdraw a plea of guilty must be legally granted, especially where in this case no trial is commenced. The record shows circumstances that can't raise suspicion on veracity and voluntariness of the guilty plea. Again, I point to when you look at the transcripts of this plea, he clearly clearly had issues with understanding the plea and understanding the ramifications of this plea. And I point to number 10, that the defendant's position that part of sentencing, the defense counsel did not share or review the pre-sentence report with them. Further, that he did not articulate in a manner that explained to the defendant the effect of his plea on his parole, and that the court granted him several additional days to think about it. But further on paragraph 12, and I'm sort of reading from the transcript, the court held a sentencing hearing. The court explained to the defendant that because you are not going to trial, you could not have a trial issue to arise that could you have appealed. But because you are not going to trial, you're not going to have it. And then it breaks off intelligibly. And so I don't know if that response, if Mr. Smith's response was knowingly and voluntarily made. And that gives me, again, great concern. I think Mr. Smith didn't realize that once he pled, that some of his trial rights would, not all of them would be gone, that those would no longer be an issue. And finally, Mr. Smith stands before you today with dead time. He's been incarcerated since this event, and he could have easily been on his way to the MDOC serving his time. But now he stands before this court willing to spend more time incarcerated to put forth his innocence. I think that shows a lot. Again, Mr. Bernstein, pursuant to the defendant, didn't pursue his case with vigor, always told Mr. Bernstein he was innocent. My client pled guilty absent a full investigation of the facts, i.e. the knife, sending it to be analyzed. And I think that he has enough here to show that there's a possibility he's met the burden to show that he's innocent of these crimes. 2 knives were used. He did have defensive marks on him, and the complaining witness testimony has not been consistent from the first time she called the 911 to the time that she testified at preliminary exam, Your Honor. Further, I would request that the court needs more information or more fact-finding, and we set up a Ginther hearing on this matter in order to get to the bottom of the relationship and ask these questions between Mr. Bernstein and Mr. Smith. I think it's troublesome that the plea was taken as it was. I think it's troublesome about what I've heard about from Mr. Smith regarding Mr. Bernstein, and I would ask the court at this time to either set a Ginther hearing on this matter or grant his motion to withdraw the plea, Your Honor. Thank you.
Okay, Ms. Flynn?
Judge, I'm not gonna, you were there for the plea. I mean, we gave Mr. Smith numerous chances to make sure he felt good and that he wasn't under duress. In fact, you haven't talked to him about duress. Like, hey, listen, like, if you're gonna plea, you gotta plea, and it has to be you, and you have to be the one who has to make the factual basis. We adjourned it. We came back on a Friday so that he felt comfortable and he could speak to his family about pleading. So, Judge, you're the one that determines voluntariness, and you determined at the time that he took the plea that it's voluntary and knowing at the time. You went over his trial rights with him. You explained to him, and I know that on the actual transcript it cuts off, but when you went over it, he heard, I was there, he heard what he was giving up on the record when he took the plea. As far as the evidence that indicates he's innocent, the fact that there's 2 knives, I don't understand how that indicates he's innocent, or the fact that Ms. Defense Attorney is saying that there was defensive marks. There's nowhere in the police report that there were defensive marks. He has some injury to him, but that doesn't mean it was defensive marks at all. And then as far as a Ginther hearing, there's been no address of ineffective assistance of counsel, or she hasn't gone over the elements or even shown the case law that Mr. Bernstein was ineffective at the time. So another motion would have to be filed in order to grant a Ginther hearing at that point. Judge, I'd rely on what I submitted in my motion in brief and ask you to deny his motion. Thank you.
I may respond to that. Thank you. Okay. First of all, saying that his injuries weren't defensive in nature, he had cuts on his hands. He had cuts. Secondly, as far as the elements of the Ginther hearing go, we could file another motion, that's fine, but I think the court has heard enough to make that decision at this point, and if the court wants to file a motion on that, we will. But I believe that it's entailed into what I have put forward, and the court's well aware of what the elements are of a Ginther hearing. I think that based on, the court going over the plea with Mr. Smith, okay, well, that's the court's interpretation of what he knew. That's the court's interpretation. That's not what Mr. Smith is telling us now. Mr. Smith is providing new light into the aspect of what was inside and his understanding of what was going on, and it is not anywhere near what Ms. Blanche is putting forth. I'd also like to direct the court that Mr. Smith is an individual who only completed the 9th grade. He has not returned back to get his GED. And so when you're talking about complex decisions, complex issues, I think that plays a part in this. Mr. Smith completed the 9th grade. Every time that he was at sentencing before this court, he clearly struggled with understanding what was going on. I read the transcript. I read the transcripts a couple of times. That is my impression. I wasn't there, but that is definitely my impression of reading the transcript. And again, Mr. Smith is here telling this court, I'm innocent of these charges. I think we can't downplay this. He is here on dead time. He's not getting credit for the time that he spent in jail so far. He is here on dead time, and now he's willing to go further to prove his innocence. So I believe that the court should allow Mr. Smith to withdraw his plea and set a date down the road for sentencing. We are not prepared to go forward with sentencing today. I have some more work to do with Mr. Smith as far as going over things with him. Plus, I don't believe it was up for today. So I would ask the court to allow him to withdraw his plea and/or set a hearing and allow Mr. Smith to put forth what the relationship was between Mr. Bernstein and Mr. Smith. Thank you, Ron.
Okay. So as to the defendant's motion to withdraw the plea, the defendant seeks to withdraw his plea on the basis that he was under the impression that he was to be sentenced to half of the bottom of the guidelines. I've gone back through everything, and I find nothing in the record to indicate that. So I can't speak to what his mind would have understood or would have comprehended, but there was never any offer on the record by anyone that would be part of any of this. So,
If I could explain that, Your Honor?
I mean, you're welcome to, Ms. Cracher. I've let you speak twice. I'm going over what you filed, so go ahead.
And so the issue to that is I believe that was conversations that was going forward between Mr. Bernstein and Mr. Smith, that there's conversations that you'd be sentenced to.
So you're asserting that Mr. Bernstein just made up stuff, that he practices law in this court every week, and that there's nothing on any record that indicates half of bottom of guidelines. Nowhere. So you're saying right now that Mr. Bernstein just had those chats with his client, like, judge is going to give you half the bottom of the guidelines.
What I'm saying is that there was, and it sort of makes sense, when the PSR originally came out, the guideline sentence came out at 14 years. If you look at that's.
Go ahead. I'm not going to go through the file right now.
That's great. It comes out of 14 years. Okay. The offer from Ms. Blanche was roughly half of the 22 years. Okay, that was the, what I perceive maybe the correct minimum guidelines. So I think there was some confusion over the guidelines when they initially came out and what they would come out to be. I'm not saying Mr. Bernstein said, judge is going to give you half. I think there was confusion over the bottom number.
Right, but there's confusion often at every sentencing, Ms. Frazier, that you've been involved with, Ms. Blanche, Mr. Feaster, Mr. Goldstein, everybody in this room. That's why we go over the guideline scoring. That's why we put that all on the record, is to go over the guideline scoring to make sure that it's accurate.
Right, but I think that I've never seen a disparity like this. From 14 years to 22 years, it's a huge disparity. So that's what I'm saying about that.
Okay.
So.
All right. What I will note, having gone back over the record, is that the plea and the sentence agreement were placed on the record on November 3rd. So that, I believe, was a Thursday. At that point, your client, as he is wont to do, spoke right up and said that he needed time. He needed time to talk to his family. He didn't understand, or I don't know if he said I didn't understand when I went back, but he definitely asked for time. At which point we then said, sure, you, Mr. Smith, I'm going to give you this time. I'm not going to force you to do this today. We came back the next day. I think it was during my civil or domestic docket or something like that. We literally carved out time to go back on the record on this sentencing, at which point Mr. Smith availed himself of the agreement. And I'm not challenging you, Ms. Frazier, on your client's education level, although he is incredibly articulate and has no trouble speaking up. But I want to also point out to you that, the general scripting that I do is incredibly consistent. And I don't proceed if I don't get a yes answer. So that idea that you understand, sir, that you are giving up certain rights that you would be able to claim appeal of issues that might have arisen during or after your trial, because you're not going to have the trial on this matter, is a precursor to me hearing the defendant say, yes, I understand that. And that happened. So I'm telling you that it isn't the court's impression or interpretation of that. I wouldn't have proceeded if he had said, sir, I don't understand that. So that didn't happen. Both of those dates, the November 3rd date and the 4th, it was clearly stated that in exchange for the no contest plea to counts 1 and 3, that count 2 and the habitual 4th would be dismissed. And that further, the sentence agreement between all the parties of 11 to 25 years was placed on the record. At that hearing, the defendant affirmatively stated he understood the agreements and that he wanted to proceed. The court assessed that the plea was knowing, accurate, and voluntary. Based on that, despite everything that you bring up today, there is no legal basis to allow him to withdraw his plea at this time. On a procedural note, Ms. Blanche is correct. There's not been a motion filed for ineffective assistance of counsel. You certainly have alluded to that, and I'm not turning a blind eye or a deaf ear to that, but I don't think I can make a ruling. I couldn't grant your request for a Ginther hearing, and I'm not telling you I would or I wouldn't, but I can't do it unless it's properly before the court. But what is before the court is the defendant's motion to withdraw his plea. Based on what I've just placed on the record, I am denying the motion at this time. I am going to set a sentencing date in this matter. Agent Marshall, this is an unusual situation, but the defendant is sitting on dead time right now. What I'd like to do is arrange for an updated PSIR. I'd like to set the sentencing date in 2 weeks. That way, Ms. Frazier, if you need to file a motion for a Ginther hearing, it'll give you some time to do that. I'm not urging that you do it. I'm just giving you 2 weeks rather than 1. And that will minimize if there is any further down or dead time for your client. So I'm scheduling the sentencing in this matter for May 3rd at 1:30. And Agent Marshall, if you can pass that on so that we can get just an updated PSIR for that.
Your Honor, I'm actually looking at a complete research report.
Outstanding. So then the answer is yes.
Right, we can make that happen, right? We just specifically want the jail time change and the corrected date.
If there's anything that needs it, it's not that it's that stale, but I don't want to come in here with something that's now a couple of months old and we'll try to do that. So if you can just update whatever you need to, we'll be back here on the 3rd at 1:30. Ms. Kracher, again, if you're filing a motion, then you'll have some time to do that. Okay?
Yeah, thank you, Your Honor, for hearing us today. You have a good day. Thank you.
Yep, thank you.